My name is Dinesh Rohi. My registration number is 2139472, and I'm presenting my first case. Sarvesh Mohan Saxena versus Sanju Saxena. Facts. In this case, a husband sought the restitution of his conjugal rights. The appellant, Sarvesh Mohan Saxena, filed an appeal against the family court's decision, which had denied to restitute his conjugal rights. The appellant alleged that his wife had deserted him and no more lived with him. According to the appellant, he got married to the respondent Sanju Saxena in the year 1995. In 2006, the respondent, along with their two children, left him without any sufficient cause. The respondent informed that she is already married to Shambhunath Sharma and the appellant was her brother in law as her elder sister was married to him. She made illicit relations with her brother in law, out of which these two children were born. In the year 2006, she fled from the house of the respondent and sought help from a police inspector and later married Shambhunath Sharma. Her sister was her sister was still married to the appellant and they also had three children. Legal issues of the case. Three issues arose pursuant to the facts of the case: whether the petitioner deserted the appellant and denied to fulfill her matrimonial obligations, whether the petitioner and appellant were legally married and can be considered husband and wife, can the appellant ask for the restitution of his conjugal rights, rules of the case. Following sections of the Hindu Marriage Act were applied as a legal rule in this case 3. Section 5. It lays down the conditions for a valid Hindu marriage. A marriage between a Hindu man and a woman can only be solemnized if neither of the parties have a living spouse, none of the party at the time of marriage, A, is incapable of giving valid consent due to unsound mind, B, is suffering from a mental disorder or unfit for procreation, though capable of giving valid consent, C, get persistent attacks of insanity. Third, the age of the bride and bridegroom should be at least 18 and 21 years respectively. The parties do not fall within prohibited degrees of relationships unless there is a custom permitting such marriages. The parties are not sabindas to each other unless there is a custom permitting such marriages. Section 9. Section 9 provides the provision for the restitution of conjugal rights. It lays down that if either of the parties to the marriage has withdrawn from the society of the other, or in simple terms have deserted him, the party so deserted can file a petition in the court asking for restitution of his conjugal rights. The court has to restore the conjugal rights unless there is some legal ground or any hiding of truth by the aggrieved party. Also, the explanation of the section provides that if there is some reasonable excuse for desertion, the burden of proof lies on the party who has withdrawn from the society. Section 11. This section lays down that any Hindu marriage in contravention of Section 5 first, Section 5 fourth, and Section 5th will be a void marriage. Such marriages can be explicitly declared null and void by a degree of nullity by the court upon a petition being filed by either of the parties. Section 28. It provides the provision for appeals of degrees and orders passed under HMA. An appeal under this section can be filed within 90 days and in front of a court to which appeals usually lie under civil jurisdiction. Section 9. The Family Courts Act 1984. This section lays down the provisions for an appeal in the case of a family matter, notwithstanding anything contained in the Code of Civil Procedure. Analysis and conclusion. In this part, I'll discuss what the court has ordered and what is my personal conclusion on it. Upon re examination, it was found that the appellant was still married to the elder sister Madhu. Section 5, first of the HMA, lays down that a person cannot marry if he has a living spouse. Section 11 provides that any marriage in contravention to Section 5 first will be null and void. The appellant was already married to the respondent's sister Madhu and never obtained a degree of divorce. He entered into a relationship with the respondent while being already married. Such marriage of respondent and appellant under Section 11 was a void marriage. Section 9 provides the provisions for restitution of conjugal rights when there is a valid ma- marital relationship as per Section 5. As the marriage itself was void, therefore, Section 9 of Hindu Marriage Act did not come into play. The Honorable Court dismissed the appeal of the appellant Sarvesh Mohan Saxena and upheld the decision of the Family Court. This case rightly laid down the consequence of a void marriage In such cases, neither of the parties have any right or duty towards the other, and the court was right in dismissing the appeal. Thank you.